Let's get everything going here, make the most of our hour tonight. Thank you so much for joining GLAD Law's community webinar regarding the Massachusetts Parentage Act. My name is Jordan Wilson. I use he and him pronouns, and I'm the executive director of COLAGE. If you're not familiar with COLAGE, COLAGE is the only national organization dedicated to empowering people with one or more LGBTQ plus parents or caregivers, so your children. We're really excited to be a part of the Massachusetts Parentage Act Coalition. So grateful to the leadership of GLAD Law on getting this incredible piece of legislation that's protecting so many of our families enacting here in January. I do want to start just by acknowledging that part of the reason that we're here and part of the urgency of this is that it's been a really tough week for our community, for our families. There's a lot of fear out there about what might be coming in the new administration. And one of the reflections that I've had in being a part of so many conversations just like this one is how our community is really banding together and really making sure that everyone feels included and part of the conversation and part of the community and safe. And that is my personal goal as the ED of COLAGE, to really make sure that collagers across the country, no matter where they live, who their parents are, what their living conditions are like, that they feel safe. And I know that my colleagues here on this call and at GLAD Law are also doing everything that they can to make sure that our community is safe. Hence this incredible webinar that we're going to put on for you tonight to really get into the nitty-gritty about the Massachusetts Parentage Act and exactly what you can expect and how you can protect your family moving forward in January. So I'm going to introduce very briefly our incredible family law attorneys who are going to be walking through a lot of important pieces of information tonight. Polly Crozier from GLAD Law, Caitlin Cardozo Egleson, and Dean Hutchison. We're going to be talking tonight about the MPA overall, what it does and what you can expect. VAPs are voluntary acknowledgements of parentage. DFPs or de facto parents, as well as surrogacy and other regulations. Co-parent adoption is something that may come up, but is not going to be the focus of tonight's webinar. We are planning on additional pieces of information to come out, resources, future opportunities to really dig into those issues. So again, they might come up, but they're not necessarily going to be the focus tonight. And just one other note, we are going to have time for Q&A at the end. So if you do have questions, please make sure that you're putting them into the chat. We'll be happy to sort through them and get as many questions answered as we possibly can when everyone's done presenting. And with that, I'm going to turn it over to my other co-moderator, Gabrielle, to talk us through the rest of the agenda.
Thanks, Jordan. My name is Gabrielle Navarro. I use she, her pronouns, and I am GLAD Law's Public Information Manager, meaning that I run GLAD Law Answers, our legal helpline. Tonight, we would love to give a huge thank you to the over 60 organizations and families who made up the MPA Coalition, co-led by GLAD Law and All Paths Family Building, and supported by lobbyist Arlene Isaacson. This coalition acted as a powerful support for the diversity of families in Massachusetts. We would also like to thank Governor Healy and the Attorney General for supporting the Massachusetts Parentage Act, and to take this moment to acknowledge that none of us are alone, but have the support of the people and organizations mentioned, as well as those on this call tonight. And I will pass it over to GLAD Law's Director of Family Advocacy, Polly Crozier.
Thank you so much, Jordan and Gabrielle. It's fantastic to be here and to be here with everybody to talk about this exciting new act. I feel really grateful to be able to talk about this law at this point in time because there is really tremendous hope in this law and so much support behind our community and behind really all children in Massachusetts to make sure they have what they need. So the first important piece of information I will share is the Massachusetts Parentage Act is effective on January 1st, 2025. So we're having this webinar tonight to give you a preview, to make sure you know about coming attractions, but we'll obviously be back in touch with you again after January 1st and time again to share resources and remind you about this new law. Next slide. First, I just want to share with you a little bit about what parentage is. So legal parentage is that legal tie between a parent and a child, and it is so incredibly important for the well-being and ability of children to thrive because it is the source of so many rights and responsibilities. Here are just a few on this slide, but of course, some of the key ones are the ability to make medical decisions, the duty of child support, right? The ability to have custody and inheritance rights. We work so hard to pass this bill together because we know parentage, it's so important for that legal parent-child relationship to be established. Next slide. And here's an overview of all the paths to parentage. One of the things the Massachusetts Parentage Act did was make sure that Massachusetts statutes clearly provide guidance to the court and to lawyers and to people like you and me of all the different paths to parentage and how to establish parentage in each path. Birth, presumptions, adoption, acknowledgements, and we're going to talk about some of those paths tonight. Next slide. So, what is the Massachusetts Parentage Act? It is essentially making sure that all children have access to that parent-child relationship, right? It has changed our laws to make sure that in black and white in our statutes, each child has a path, which makes sure that our statutes are constitutional, make sure more people have access to the courts to be able to protect their children, and also make sure there's more consistency throughout the state, right? Rather than one judge doing one thing and one judge doing another thing, this sends a consistent message to judges about what they're supposed to do. We're grateful to the bipartisan sponsors of this bill, as well as our lobbyists. This bill had tremendous support in the legislature, as well as with the governor and the AG, as Gabrielle said. Next slide. I want to leave this message here for you to read, which is just one piece of this 50-page bill that happens at the beginning and is one of the key additions to our statute, that essentially every child has the right to parentage, no matter the gender identity, sexual orientation of their parents, or how they were brought into this world. This is about equality. Next slide. So what does it do? I'll give you some of the highlights. First of all, the language of the law makes sure that our statutes are gender inclusive. So we're talking about parents. We're talking about people who gave birth. We're making sure that the marital presumption includes LGBTQ couples, just like non-LGBTQ couples. We're making sure that both married and unmarried parents can establish parentage through voluntary acknowledgements. A little bit more about that in a minute. We're making sure that de facto parents can be equal legal parents. We're ensuring there are protections for children born through assisted reproduction and protections for children born through surrogacy. And here's a picture of one of our coalition families. Next slide. So let's take a second to talk about what voluntary acknowledgements of parentage are. Voluntary acknowledgements in parentage actually exist in every state because the federal government requires each state to have a free, simple, voluntary process to establish parentage in the states. So the Massachusetts Parentage Act essentially expands access to more people. So now, not only kind of mother, father, genetic parents who are unmarried can sign voluntary acknowledgements, but married parents can, and children and parents of children born through assisted reproduction. So what that means is, for those of you who have recently, are just about to have a child or are thinking about having a child, it means that in the hospital you can sign a form and parentage is established as a basis on that form. So it's really very quick after birth. It is the equivalent of a court decree of parentage. Now, given the tremendous hostility we're going to see in the next administration, many of our families are also going to want to do judgments of parentage or co-parent adoptions. But particularly because this is available right at birth, and particularly because it's very easy to do, it is a very important protection. And Massachusetts has now joined 11 other states in expanding access to voluntary acknowledgements of parentage to LGBTQ parents. So to talk a little bit more about a new route to a judgment of parentage under the Massachusetts Parentage Act, actually, I'm not passing it over to Caitlin. I'm going to talk about de facto parentage first. Sorry, we had one of our panelists who was sick tonight. So next slide. So let me tell you a little bit about de facto parentage. We are missing our youth advocate tonight, Darmani Jimenez, who usually talks about de facto parentage. He is with us in spirit. So a de facto parent is somebody who, with the support of the child's existing parents, becomes a parent of the child because they've acted that way, because they have functioned in a permanent way and stepped up to take care of a child. It could be well after a child is born, could happen at any point in the child's life. It is a functional parent. And the Massachusetts Parentage Act now makes sure under statute that these parents, once they meet a rigorous 7-part test, are full and equal legal parents. This also means that in Massachusetts, the court has the discretion to say that a child has more than 2 parents. A de facto parent can be added on for a child in addition to the child's already existing parents. And this is really important for children like Darmani, whose de facto mother stepped up to take care of him and his siblings and make sure that he had what he needed and he didn't go into foster care. So we're really excited about this provision of the law. And now I'm going to pass it off to Caitlin to talk about assisted reproduction.
Hi, my name is Caitlin. I use she, her pronouns, and I am a family law attorney. I am a partner at a boutique law firm. We focus on family law and estate planning and administration. And while we don't exclusively serve the LGBTQIA plus community, it is really where we focus. I am also a parent who went through the process of securing legal parentage for my spouse. So I'm here and I'm really excited to talk about the parts of this law that give new paths to parentage for parents of children who are conceived through assisted reproduction. Mass is, as Polly noted, joining other states who have similar laws that give additional options other than the co-parent adoptions, which are extensive, timely, and can be expensive. And these are paths to get a judgment from the court for parentage. And this is important because of the full faith and credit clause of the Constitution, which says that states must respect the laws and judgments of courts from other states. So this law provides consistency and easier access. As a practitioner who has up until now done a lot of co-parent adoptions, I have a spreadsheet of all the different counties and the different requirements that they each have, because we haven't had consistency. And then it can even get down to the level of different judges wanting different things. So this law does a bunch of things. I'm just going to highlight some of the big picture ones. And one to point out is that assisted reproduction is defined broadly. So under the new law, it is explicitly anything except for conception through sexual intercourse. So that means doing at-home insemination, IUIs, being at the doctor's office, IVF, all of the ways in which we create family. It also, covers if you're using a known donor or a cryobank. And the other thing that this law makes clear is that if for the first time it says that a donor is not a parent. So we went from not having any statute at all about donors to having a great one. Sperm donor, egg donor, they are not a legal parent and they are not entitled to notice. So as the law stands now, a donor, there is a provision that says that, that you do have to give notice. And so what we routinely do is ask the court to waive that notice. So anyway, it's really, again, streamlining the process because of this law. So the other kind of big picture idea that I want to highlight is that consent to assisted reproduction means that you are a parent and you can establish legal parentage by showing that you consented. And, how do you show that you consent? Well, I'm a lawyer. I like things in writing. So certainly, having something in writing that is a good, clear way. And that could be, a written, signed recording before birth, at birth, post birth, an agreement written up by a lawyer. However, if you don't have something in writing, then the court can find that consent is there by evidence of an oral agreement and also signing forms, for example, for IVF. So there are some different concrete examples of those. So next slide, please. So, again, this law provides that children conceived through artificial reproduction, that parents can get a judgment of parentage through the court before or after birth. Courts are supposed to issue that judgment, provided that there's a showing of consent. And this is a very different process than the co-parent adoption. It is much simpler, much more streamlined, excuse me. And co-parent adoption will still be available. And again, that's not the topic for tonight, but certainly there will be more information provided. My office is a resource if people want to talk through that more. Certainly kind of what we're focusing on all day, every day these days. And this coalition that brought this really important law to be is working on the forms that are needed to get these through the courts. We don't have those yet, but we will be working on them and we will get them, make them available for people to see. That's what I got.
I think I think I'm up next. Is it surrogacy next?
Yes, I'm sorry, I didn't
it's all right.
pass the baton.
So I'm Dean Hutchison, and I'm going to talk to you a little bit about how the law impacts surrogacy, another form of assisted reproductive, or one form of assisted reproductive technology. I work at what's called a surrogacy agency here in Boston, Massachusetts, called Circle Surrogacy. I've been a lawyer for the last 23 years now. It's a long time, and mainly focused on the kind of area of fertility and family law, and particularly in-house at this surrogacy agency the last 14 years. I also chaired the American Bar Association's Committee on Assisted Reproductive Technology Law for 6 years in that span. So it's an amazing area of law just because we are there helping build families in the little we do. To add to the progress we've seen around the country. Now, surrogacy, just before I get into the terminology and the statute itself, it has been practiced here in Massachusetts for the whole time I've been doing it and preceding me. And we've always had good case law. And what's funny about like Polly's initial slide about parentage, really surrogacy law came about because there was a woman pregnant with someone else's child. They were about to have a delivery. And there was nothing really for the courts to look to grant parentage to the real and what we call intended parents. So the decision talked a lot about you need the right person making medical decisions. You need the right person for health insurance to protect the child. You need the right person for all these things to happen before the baby's born. And because we don't have any law in the books, we're going to make what's called an equity decision to grant parentage rights to the true and intentional parents of this child. And from that, in the dicta of that case, they basically said, hey, legislature, you better start legislating on this because we don't have anything. And lo and behold, it took us 20 plus years to get there, but we're here. So this statute really was a call to arms years ago. And then I've been happy to serve alongside many of the advocates on this call that you've already heard from to push our legislature pretty hard the last 9-10 years to finally get to where we are. And we finally kind of codified, and not only codified, but expanded who can do surrogacy in the Commonwealth and who's protected under the statute. And the end all is what we truly wanted to protect is the children to be born so that they have caregivers and they have their true parents from the moment of birth on. So for those of you who don't know what surrogacy is, there's two types. There's one that's called gestational surrogacy, and that's when a person who is not an intended parent agrees to become pregnant through assisted reproductive technology using gametes, which are sperm and egg, that are not their own. So they have no genetic connection to that child they're carrying. It's either two intended parents, sperm and egg, it's a donor and a parent, or two donors, but they have no genetic tie to that. And then we have what's called genetic surrogacy, or some of you may have heard back in the day referred to as traditional surrogacy. And that's where a person who is not an intended parent becomes pregnant through assisted reproduction, but they are using their own gametes. So they are a source of the egg that is going to be in. Now, prior to the statute, you could practice both, but they were very different in how you came about parentage at the end. But now through the Mass Parentage Act, there's a simpler way to get parentage, whichever process you choose, and it's all codified under the law. Right? So you can go to the next slide. So really the general background on surrogacy and what can happen. So basically it's parentage by consent of that agreement. So it's the parties getting together prior to conception to show their true intentions on who the parents are and who's not going to be a parent. And they're doing this agreement that kind of solidifies that relationship and what that expectations are. And really based on the law, from the moment that contract is signed, the true parents or the intended parents are the parents of the child. Now, the specific requirements to enter into the agreement, parties can be no less than 21 years old. So everyone's going to be 21 or older. There are going to be mental health consultations required prior to doing any of the IVF process to do the transfers to the surrogate. So the intended parents and the gestational carrier or surrogate will have that mental health consultation done. The surrogate or gestational carrier must have given birth prior to and have a child in a sense prior to entering to a surrogacy agreement, so that medically as well as emotionally people understand that she's been able to achieve a pregnancy. She hasn't had medical issues, because you don't want to put someone at risk not knowing what their medical history are from a pregnancy perspective. The agreement itself must be executed by the parties prior to conception. So there's no, you can't get pregnant and then sign the agreement and go through it. You want everything in place in advance. The agreement can't infringe on the surrogate or gestational carrier's right to make her own medical health decisions. So you can't, dictate her, who she uses as a doctor, what procedures she's go through, et cetera. She has her own right to make all those decisions. And very smartly by the lawyers of the world, we made sure you had to have lawyers involved in these contracts. And make sure if you are doing this, that you're using lawyers that actually are experienced in art and surrogacy law, because we always, probably everyone on this call that's been on the other side of a contract with, my mother-in-law's real estate attorney is going to help me draft my surrogacy agreement. Go to the experts. There's a lot, because we've had such a long history here in Massachusetts of art law. There are a lot of good practitioners, and many on this call already, that have great experience dealing with these contracts. So next contract, our next slide. So the surrogacy, now the little difference in nuance in the gestational versus genetic surrogacy agreements must be approved by the court prior to conception. So if you're going to work in one of these scenarios with a gestation or with a genetic surrogate is going to carry, you actually get court approval at the time of agreement, and then you get another court order from a parentage perspective, just to add a little bit more safety net into those contracts. Whereas with a gestational carrier agreement, you wouldn't pursue your legal parentage until there's a pregnancy. What we also added in to the agreement is that a time limit, really. Now, from the majority of the time I've practiced in this Commonwealth, you usually get the order in time in advance of birth. But we do have different courts with different timelines, with different judges and different clerks. So suddenly you could get a court date that was, 6 days after your due date, even though you filed it at 18 weeks pregnant, and you'd have to push the court for expedited hearing. So what we tried to do, not only make this whole process efficient and more streamlined and more simpler to go county to county and judge to judge, but also speed up the process so that these are all 99.9% of them around the country are consented to court proceedings where all the parties are in agreement. They're simply filing it to go through the motion that's required under the statute. There isn't going to be any contest, so the court should be able to act very quick on them because they are not disputed. All the parties want it done. So we've added this 60-day window to get a judgment, which hopefully works quicker than that. But we're always in this field when we're applying. We're usually submitting these court proceedings or court documents to the court, very early on in the pregnancy to get that court order well in advance of the birth. It also allows for post-birth orders, which the last last case law didn't. So if for some reason the baby comes early and the court order isn't in place yet, we used to potentially have to go a whole different route for parentage. The statute allows us to get an order pre or post if necessary. So you'd still be treated as the parents at the hospital. We'd have other documents in place, but we don't have to worry about doing a much longer route to parentage at that stage. We will get an immediate post-birth order if that were to happen. So it's very positive. It's great. I mean, we've always been a wonderful state to live in terms of parentage rights and both for all sorts of families coming to the courts. We've always been progressive in pushing these limits. This statute maybe took a little too long to get to because we've had such good law happening that I think the legislature didn't think it needed to act, but it couldn't have acted in as better of a time to put this in place to add further protections and further consistency to all the families out there that want to pursue that path to parentage, whichever way they choose. So I'll stop rambling and let us get to questions, but thank you all for listening, and I'm happy to answer any questions tonight. My email is on this page as well. If you'd rather ask me something directly, you don't feel comfortable asking in a group setting, I feel free to reach out to me. I will do my best to get back in touch as quick as possible.
Thank you all so much for really downloading an incredible amount of knowledge to quickly answer at least one of the questions that has come in. Yes, this information will be available after. We will make this recording available, and so folks will be able to share with other people who might not be here right now, other attendees who couldn't make it, and also look out for future events. We're not done talking about this. This is really just the beginning of all of the ways that we'll be working proactively to protect our community and our families, especially given our new fun political situation. So I want to dive into the questions and make the most of the time that we have. One of the first question themes, so not one person specific question, but one of the themes that's coming up quite a bit is if I have this voluntary knowledge of parentage, am I good? Like, is that all I need to do? I can, travel the country, travel the world, and I don't have to worry about getting a co-parent or second parent adoption. Like, everything's Gucci. What is that? Sorry, I'm speaking in my youth parlance, and maybe I shouldn't.
I love that. I'm going to jump in and then pass to Caitlin or Dean to add on. Such a great question. And first of all, obviously, we're just here to provide basic information, right? For specific questions, please feel free about your particular situation because everybody's family is different. Please reach out to Glad Answers for referrals, Caitlin, Dean. Like, there are people here to help you with your individual questions, so don't hesitate to reach out. In general, let's say this: you've got to do something. If you take nothing else away from this, do something. Don't not take any action. Don't Marriage is so tremendous. A marital presumption is a presumption. And so we, as lawyers, talk about, you want to get something more. You want to get a decree or a decree equivalent because of the Constitution. The Constitution and court cases say that a court judgment gets exacting full faith and credit. So with a judgment, you can go to any jurisdiction and your relationship is secure. So that's why for married people, unmarried people, we talk of the same. Do something. I will say, it depends on what kind of, if you have a marital family or a non-marital family, here's what I will say in general, okay? A voluntary acknowledgement of parentage should be enough. Under federal law, it is the equivalent of a court decree. It is used in many states. It is, and I will say for me, like you can do it in the hospital for free. Why wouldn't you? Right? I think given, of course, we have expanded access to voluntary acknowledgements in 12 states right now, right? So in my mind, you know, we're in a little bit of a shifting environment, to be honest, a weekend. We are going to keep you updated. GLAD has a voluntary acknowledgement of parentage page where you can learn more and stay up to date. I will say this, given the hostility that we're going to be facing, or we already do face, I think a lot of people are also going to want to do a judgment as well. But that judgment, it can be a judgment under the assisted reproduction provisions of the new law that Caitlin talked about, or an adoption. Either a judgment or an adoption, they're both court judgments. And what we have seen in other states that have already passed comprehensive parentage reform, I've had the luck of working in many states to update their laws, is that those assisted reproduction provisions, that judgment is easier to get, it's faster, it's less expensive, and that's a great path to getting a judgment. So I think in this moment, it's kind of a belt and suspenders time.
Any follow-up on that, Caitlin or Dean?
Yeah, I mean, honestly, not much, given that response from Polly. I do want to underline, do something. And I will say, you know, the law in Massachusetts is, you know, the marital presumption. So when I was advising clients about second parent adoptions before, it was also kind of a belt and suspenders thing because the adoptions are supposed to get, I'm sorry, the mass law about parentage, so that, you know, the parties of a marriage, when a child is born, while those two people are married, they both have legal parental rights. And so I was always telling my clients, you know, the second parent, co-parent adoption is a belt and suspenders because we know that adoptions are recognized on the federal level. And I think that some of this is going to be, you know, kind of rolling out. We are going to be responding to things in real time and seeing how things play out. And I think it's going to be also a question of people's risk for tolerance, tolerance for risk. That's what I mean. And so, you know, I think it's just it's so clear that adoptions are recognized on the federal level. And so we all already kind of know that, and it's really easy to ground in that. Again, this law gives other options. And then, you know, it's going to be up to us as individuals to decide which path we want to pursue. But certainly, just to make clear, just signing the birth certificate is not a judgment of parentage. So I just want to also make sure that's highlighted. Thanks.
Thank you both so much. We're also getting several questions regarding how folks get their judgment of parentage. Can anyone speak to that?
Well, I'll talk about section 27, which is the assisted reproduction provisions, and then I'll pass it to Dean, maybe to talk about section 28, which is surrogacy. So Section 27, to get a judgment of parentage under the assisted reproduction provisions, stay tuned. The coalition is in the process of supporting the court system to develop the forms. They, of course, have until January 1 of 2025 to put those forms out there on the public website to be available for people. I have a feeling we're going to host a webinar after January 1 to show you those forms and walk you through them, as well as the new updated voluntary acknowledgement of parentage form, the draft of which landed in my inbox today. So just rest assured, we will guide you on how to do that and also provide referrals to lawyers who know how to do that. But what I can say is it is going to be going to be a court process in the probate and family court. It will be a more streamlined process than adoption because you don't have to waive all the requirements under the adoption code, right? The adoption code says you have to live with the child for 6 months. You have to do a home study. You have to do a criminal record check, all of those things. In this code, what you have to, in Section 27, you have to show I consented to assisted reproduction. So it's very different. So anyway, so stay tuned. We will provide that information as soon as the courts have finished it. And Dean, do you want to talk a little bit about yours?
Yeah, so parentage through surrogacy, it's a little on the stay tuned mode in the sense that we're trying to produce forms as well, and as Polly said, we're meeting with the judiciary next week, but it'll probably be similar to the way we already do it. There'll be a petition to the court that the parties sign. There will be some affidavits in support, either from like the doctor who did the IVF procedure, showing who the parents are, usually affidavits from the parents and maybe the gestational carrier and spouse. And the only new thing in the statute is a copy of the agreement itself. The carrier agreement gets filed. These are all filed under seal as well, so you don't have to worry about it being out in the public and things like that. But so that's usually filed. What we usually say is by like maybe 20 to 24 weeks pregnancy is when it gets filed. You're then looking at a court order. Each county has been a little different in the past. We're hoping with the streamlined approach that everything is done, what we say is in the legal world, on the papers, where they just simply get it. Since it's a consented to proceeding, the judge is signing off on it within those 60 days. It gets sent back to the parties and your parentage is established. The genetic surrogacy, which we talked about a little earlier, where the carrier or surrogate is the egg donor in the situation, will be a little different in that you'll petition the court at the time of signing the agreement so that they authorize you to move forward as a party, and then you'll submit those papers again for parentage after. So there'll be a little two-step process to it, but we've been doing it for 20 years, so it shouldn't differ much, except that we're hoping it's like the adoption forms, that it's all the same form and you're submitting all the same documents to the courts. Although, as Caitlin said, even in adoption, some courts require different filings than others, but it's mostly the same, and we're hoping that's how it goes. I will say Hampden County has always had their own specific requirements for surrogacy parentage, and I'm sure they'll add something in on these too that we'll get to. But it should be a pretty easy process as it has been in the past, but it'll be easier now in that we know there's a specific timeline and what exactly we need to file.
Thank you so much. Moving on, we have a few questions from families with more than 2 parents. So perhaps there's an ex involved. These are all folks that are, however, raising the child collectively. So specifically, is there a situation where a person who might not have been involved in the original conception or birth of the child, but is actively raising the child, qualifies as a de facto parent and could potentially get a voluntary acknowledgement of parentage? Could you walk through like what that process might look like, or anything else for folks with 3 or more parents involved?
Totally. Here's what I will say about voluntary acknowledgements of parentage. You're never going to use a VAP to establish more than 2 parents. It's just that system is not set up that way. So that's going to be for 2 parents. Now, interesting fun fact, right? Because the courts have really been, as Dean said, have been, doing a lot to try to keep our families protected and up to date in the absence of a legislative enactment. which is already the adoption code is often used by people to establish more than two parents, right? So I know adoption practitioners, you know, Caitlin's an adoption practitioner. There's others in the community who have established 3-parent families and 4-parent families. So the adoption code remains a path to do that. Under the Massachusetts Parentage Act, there is a provision called the competing claims provision. And in that provision, it says, if there's multiple claims to parentage of a child, it's in the discretion of the court, using a specific standard to determine if it's a child in a child's best interest to add on another parent. So that's a really nice kind of explicit piece of the law that says the court has the discretion to do that. Now let's take a de facto parent, for example, right? That's often a place where, you know, a child already has 2 established legal parents and someone is serving as a de facto parent. They meet the de facto parent standard. It's in their best interest to be added on as a 3rd parent. That is possible under the law. I mean, I'm sure there's going to be practitioners who creatively do that by agreement. At the moment, it's set up as kind of an adjudicatory process. But again, I think there's going to be a lot of new possibilities and room to explore under the new act. Does anybody want to add to that?
Well, I think that in the surrogacy piece as well, there's no limitation on the number of parents. So if there you know, was a 3-parent or 4-parent family pursuing a surrogacy, there's nothing barring that from getting a pre-birth order for all those parents on a surrogacy related bill as well. So there's that potential if you haven't started the family building process and you're moving towards, you know, a gestational or genetic surrogacy, that you could do it as a multiple parent family and get all the parents approved as parents under the law and have a birth certificate to follow.
Awesome. Thank you so much. We've had a few questions regarding if there are any special considerations for parents who are transgender, as well as a question regarding for parents who have an X gender marker.
Okay, I feel like I'm a mic hog. Caitlin, do you want to go ahead or no?
I'm just not quite prepared.
Okay, well, I'm gonna just jump right in.
Yeah,
Well,
go for it. I'll jump in if I can.
So here's what I will say. So one of my favorite parts of this new law is that it makes the Massachusetts law gender inclusive, right? So that means like the language talks about parent instead of mother. It talks about person who gave birth. So it is really set up to apply and recognize that there are people of all genders in our state, all of whom can be parents. And so I think that's really positive. We hope, and again, we're working with the court on this, that of course, then the forms that exist that you have to interact with should also be gender inclusive, right? So that is obviously one of our goals, to say, you know, we're a commonwealth of such diverse families and we want to protect all of them. In terms of an X marker, that's a great question. I think the answer is the same though, right? Because again, this is really about establishing that legal parent-child relationship, which is about the standards under the law and whether you meet those standards, and gender, and that those apply regardless of gender.
Yeah, and once again, I mean, I don't have that much to add, but I will say that, you know, for the community of practitioners I know who practice in this field, you know, those are great questions to bring to us for your specific situation. I know that also people have questions like when it's partner assisted conception or reciprocal IVF, you know, because it does get confusing, like, well, I'm the gestational parent, but I'm the, you know, blah, blah, blah. And so, you know, those might be good places. But I know, for example, with the co-parent adoptions, you know, somebody's gender identity has never been a complicating factor for the courts here in Massachusetts. You know, certainly it's not perfect here, but that gives me hope that as we now move into this next phase, that you know, hopefully with education and advocacy, we will see some of that same kind of acceptance by the courts.
Yeah, and similarly in surrogacy, I mean, the great part of the statute, again, like most of the statute is, it just doesn't matter. If you intend to be a parent and you want to be a parent and you go through this process correctly, you are a parent. It doesn't matter if you're single, if you're a couple, if you're LGBTQI plus, if you're transgender, your want and your intention to be a parent is what is necessary to be a parent, as the way it should be. So, you know, we had good law here. We've made it better. And I think, you know, one of the best messages moving forward is if things seem down, and I am sorry, Polly, to put you on the spot, but you have in this Commonwealth alone, probably one of the most zealous advocates you will ever get, who even when things were really good in Massachusetts and we technically didn't need this statute, she pushed forward and pushed forward, and she's done it all around the country. So, you know, we want to help you in this piece, and this piece is, you're in a great place in Massachusetts. You're in a great place now with the statute. And if things look bad, there are many helpers out there to assist. So, you know, push forward, protect yourself the way we tell you to protect yourself. Go create your families, because if you intend to be one, you should be one, and you can make it happen.
Okay, can I just throw like a big heart into the screen for that one? And something that you both said made me want to just share with this, because I used to get this question a lot when I was in private practice before GLAD, which is, even though like you might be genetically related to your child, right? Like let's say one person is the birth parent and the other person is the genetic parent, you still want to do something to protect your relationships. You still want to do something, because what you're doing is the belt, the suspenders, the clarity.
Thank you so much. And also shout out to Polly and all the incredible work that Polly does. So we have about 10 minutes left. I do want to just, for housekeeping purposes, reiterate that this information will be made available after we will make the webinar available. There will be more resources coming out. For those of you who are asking about how you'll know when the law goes into effect, or when GLAD or other organizations or attorneys are doing more info sessions, please go to the GLAD Law website. You can sign up for their email list. If you're interested in COLAGE's emails, you can go to our website and sign up. GLAD Answers is also a great place for a lot of the really specific questions that you might have. You will get a bespoke response largely from Gabrielle, but also the incredible team at GLAD Law. And so please, if you didn't get your question answered tonight, there are more avenues to getting that question answered, and there will be more opportunities like this one for us to download a lot of information and share out. So one last big question.
Jordan, can I first just hop in and give a tiny bit more information?
Absolutely, please.
Thank you. So massparentage.org will also have the latest information regarding mass parentage. So please go to massparentage.org, and we'll also send out information as it comes through to the folks who are attended the webinar tonight or signed up to be here. Oh yeah, and you can see massparentage.org on your screen. Thank you, tech folks. We really appreciate you. And I will pass it back over to you, Jordan. Thank you.
No problem. Thank you. So like we started off the call, people are concerned. Obviously, it is amazing news that Massachusetts families are going to have this protection in January and moving forward. And there is very likely going to be some federal movement on issues that are either going to impact this conversation or impact areas around this conversation. And, you know, people have those concerns. So how is this level of protection going to hold up against, you know, the worst of what we might be able to expect from the next administration, and what we might see in terms of restrictions or limitations, especially on the queer community with regard to the federal government?
Great question. I'm going to jump in on this one to say, good news for us is that the legal parent-child relationship is established under state law. So if you are a child, if you have a legal parent-child relationship under state law, that is a tremendous protection. It is why GLAAD has been working with partners like these folks on the call and other groups so hard in the states that we work on to update parentage laws so that you can access parentage and protect your children no matter what. So that is why we're sharing to you, do something. Get that protection, because with that protection, you can then travel and be protected wherever you go. Because that judgment that you get in Massachusetts, if you go to Florida, that will be that will be recognized. Okay. And also I just want to put a pitch in. We are having a GLAAD community call tomorrow night at 5:30 p.m. that will address broader questions post-election about like transgender healthcare, marriage equality, a little bit more on parentage. So for kind of broader questions like that, please feel free to show up to that or catch that recording and stay in touch on those resources. But I want to say that in the realm of parentage, the state protections are really important. And we are going to do, and GLAAD and a lot of folks in the world, we are working so hard. These precious relationships that make life worth living, we have been protecting them for 50 years. We're going to keep on protecting them. So, and we're not going to back down.
I feel like that's a great place to put a pin in this one. Does anyone have anything else that they would like to add or share before we say goodbye for the evening? I didn't think so. Polly said it all. Again, if you're looking to get connected with COLAGE, you need community for your little ones. That's what we do. Please reach out to us at collage.org, info@collage.org. If you have more specific questions, GLAAD answers. You can join the community webinar tomorrow from GLAAD Law, and we're going to be doing a lot more like this coming up. So get on those listservs, and we'll keep you all updated. Head to massparentage.org for specifics on the MPA. I think that is pretty much everything. So thank you very much for joining us. Thank you, Dean. Thank you, Caitlin. Thank you, Polly. We really appreciate all of your expertise and everything you're doing to keep us and our families safe. Thank you. Have a good night, everyone.
Thank you, everyone.